What does this say of the Office of the Director of Public Prosecutions? Because he had attempted to withdraw this case. The EACC yesterday was speaking of having, 40 former serving governors in their sights. And there are cases there, even in cases among those 40, where the DPP is seeking or has successfully sought to withdraw charges.
Well, I think, first of all, the DPP, I believe, does an excellent job most of the time, because the procedure for review of cases and withdrawal is underpinned in the Constitution, and you cannot fault someone for exercising a provision of the law that exists for that particular purpose. If you look at Article 157, Sub-Article 11 of the Constitution, it requires the DPP to make the decision to charge in public interest and in good faith, which means at the level of evaluation of evidence, if there is prima facie evidence which, if left unchallenged, can indicate the existence of an offense, the DPP is not required to have an ironclad case. What the law requires him to have is evidence that, if left unchallenged, could lead the court to believe that the accused person has committed an offense. That is what lawyers call prima facie evidence. Now, if in the course of the trial, it turns out that the witness statements are fraught with irregularities, gaps that are not easy to close, the law permits the DPP to exercise discretion and return that to withdraw the charges, reconceptualize, rearrest, and return. Section 87A of the Criminal Procedure Code exists for that purpose, to permit the DPP to terminate charges for reasons that would be stated in court, except that the Anti-Corruption Court has said the decision to withdraw charges cannot be made exclusively by the DPP. The court needs to validate those reasons, and therefore, if charges are terminated, if corruption charges are terminated, then it is a decision of the court and the prosecution, not the decision of the DPP alone. But sometimes there could be extraneous factors that could lead the DPP to propose to terminate charges and then continue again with those charges. One of those factors could be outright manipulation of that particular file. It could be an honest error in judgment, that there was insufficient evidence. It could be circumstances not permitting, because some of the circumstances that may cause the DPP to terminate or to propose to terminate charges could include public interest. Perhaps the accused person is battling what looks like a terminal ailment, and that could necessitate a review or a strategizing of whether to prosecute that accused person or not. I think for us to know whether the DPP acted in good faith or acted subject to external pressure, would have to look at the reasons that were preferred at the time of proposed termination. Unfortunately, I do not have those reasons, and therefore I don't want to speculate. And if I must speculate, I cannot speculate as to make or to infer ill motive or ill will on the part of the DPP.